Hello everyone, welcome back to my channel, and this is the last unit with regards to constitutional development that talks about, in short, what exactly is Indian Constitution, because till now we have seen is the history of Indian Constitution and how we reached till the Indian Constitution. So we see that after the independence or prior to the independence, a cabinet mission plan was formed in 1946, and initially there were 389 members, which were again after partition they were reduced to 299. And this cabinet mission plan, then Constituent Assembly entirely chaired by Dr. Rajendra Prasad, and then drafting committee. So there were different committees that were formed during the Constituent Assembly for the enactment of constitution. And again, main we should be aware as drafting committee, and the head was Dr. Baba Saheb Ambedkar, and the entire constitution took 2 years, 11 months and 18 days to draft, and it was adopted on 26 November 1949, which was again effective from 26 January 1950. So for Constituent Assembly, this is amount of information is enough for your this semester as well. In detail we will study from in next semester when we have Indian Constitution as a separate subject in our third semester as well. So you need to understand what are the basic features of constitution, salient features of constitution. That is, first, it is the lengthiest and written constitution. So Indian Constitution is termed as the lengthiest constitution because all of the state affairs are being prescribed in the Indian Constitution, and it is again very much lengthy. Then again, it is a federal structured constitution with a unitary bias. So basically it follows the principle of federalism, but again it has some unitary form of government features as well. So again, centralization of power is there. Central government is more stronger than state government. So again, federalism, if you may know, it is the crux of it. Crux of federalism is that there is a level of government, different levels of government. So again, central government, state government and local governments at lower levels, that is federal government. Then again, it is a parliamentary form of government. So that is people's government, that people elect representatives from themselves to form a government. It is parliamentary form of government. So there is legislature, executive and judiciary. All of this we will study in detail, but you should know that there are three organs of government: legislative, executive and judiciary. And again, the Indian Constitution gives us fundamental rights. That is in our part 3 of our constitution, which starts from article 12 till article 35. So there are different types of fundamental rights as well, which again we will study in detail. So fundamental rights, which we all know, are inevitable rights that no one can take us or abridge away from. Then DPSPs are given, that is directive principle of state policy, that keeps and acts as a checks and balance system towards the ruling government as well. And again, secularism also is a fundamental concept of in the features of constitution. Then again, we have an independent judiciary with the concept of judicial review. In shortly we will discuss what exactly is judicial review. In detail we will discuss in our next semester. Then universal adult franchise, that is universal adult suffrage, that people who are 18 and above can vote in elections to elect their representatives. Then again, unlike various different nations, we have a single citizenship of the center and not of the state. That is, we have citizenship of India and not of citizenship of a particular state. Then constitution can be amended. There is a procedure given in constitution itself under article 368, that is amendment of the constitution through various procedure, and power of amendment is given. Then again, if the constitutional machinery fails to operate, if there is a warlike situation, then the president can impose emergency in the territory of India. Then again, last point is preamble, that is the crux and core of our constitution is given in the preamble. That is features of sovereignty, socialist, secular, democratic, republic. The features of the constitution are all well summarized in the preamble of the constitution itself. So coming to the point of judicial review, so for this semester particularly, you need to understand the basic concept of judicial review, where it is originated and what exactly is judicial review. So first, judicial review you should know, that is whenever laws are being enacted by legislature, implemented by executive, then the power of court to review that law, whether it is in consonance with Constitution of India, whether it is infringing upon Constitution of India, that is the duty of judiciary. That is what you call as judicial review. So first you need to understand that first instance of judicial review was been talked about in the case of Marbury versus Madison, where the word judicial review was first the judge at that time was Justice Marshall, used this word that it is the duty of judiciary to keep a check on laws that are being enacted by the government at that time. So it has been derived from US, and not explicitly anywhere you will find this word judicial review in our constitution. It is a concept that is being brought away through judicial pronouncement as well. Many case laws, various case laws. So Keshwananda Bharati is there. So with this challenge, this very case challenge the 39 Constitutional Amendment Act, 42nd Constitutional Amendment Act. So these advancements that are being happened throughout the cases, Keshwananda Bharati is there, Minerva Mills is there, SP Gupta, there are many other cases as well where the concept of judicial review is elaborated. An elaborate study we will do in the next semester. So you need to understand that constitution is the supreme among them all. If any law that infringes upon constitution and it is noticed by judiciary, then it can be struck down to that particular extent it is infringing upon the constitution. So that was all with regards to judicial review. Then writs as well, a small topic is been given. So a short note may be asked on this prerogative writs in India. So you need to understand that article 32 and 226, 32 with regards to Supreme Court, 226 for High Court. So 5 writs are mainly there. First is habeas corpus, that is unlawful detention. Unlawful detention, if certain person is being unlawfully detained by a certain authority, public authority mainly, without giving him any reasons etc., then he can approach to the court by a writ of habeas corpus for the unlawful detention. Then second is with regards to mandamus, that is to command, or that is in literal sense mandamus means we command. So it is a writ can be issued in the court when a certain administrative authority, public authority is not performing its duty properly, and the court can issue the writ of mandamus commanding them to perform their duty properly. Then third is the writ of prohibition and certiorari. These are both together, we will study them just in a bit. First we will see quo warranto. So quo warranto is that if a public office holder with regards to employment, if it is not in due procedure, then quo warranto writ can be issued to challenge the authority of employment. So what is seen in public employments is that they tend to favor their candidates according to their own will. So this again violates the fundamental right of our right to equality. Then if this happens in a public office, then you can issue the writ of quo warranto that this particular public office is not functioning well, they are not doing their duties well. So you can issue a writ of quo warranto. Then prohibition and certiorari, that is prohibition means prohibit a lower court who is overstepping or exercising its jurisdiction which is it's not the jurisdiction of. So basically prohibition means that when a lower court exceeds its jurisdiction and takes up a matter, the higher court can prohibit that court and take cognizance of that matter. So certiorari is basically also the same thing, but again here the important thing is that the lower court has already given its order or judgment with regards to that matter, and the higher court will cause that order because it is again overstepped the jurisdiction, then it shall take the matter from its own. So this was all with regards to prerogative writs, and with this we have concluded the last unit of our constitutional development subject. And in the next semester as well we have Indian Constitution, then we will see all of these concepts in bit detailed manner. Thank you so much for watching. Thank you.